Thank you for joining us tonight. Welcome to the Daniel Webster Debate Series, hosted by the Georgetown Law and Federal Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rarely remembered as the great expounder and defender of the Constitution. Our resolution tonight is may the states protect parental rights, or does the Constitution protect parental rights? We are proud to host two legal giants in this debate, Professor Marcy Hamilton and Mr. Mike Ferris, to discuss the most intimate and personal of constitutional issues. We are also thrilled to host Judge Ryan Nelson, one of our nation's most dedicated and thoughtful public servants, as our moderator. In addition, I want to extend a warm thank you to Mr. Jordan Lawrence, who has been a dear mentor and role model to many of the students in this room. The debate tonight would not have been possible without his remarkably generous support and advice. Let's please give Jordan a quick round of applause. We're deeply grateful to the Federal Society and to Georgetown Law for making this Daniel Webster Debate Series a reality. I now recognize Ian Stapleton to introduce our three stellar panelists. Let's give them a warm welcome. Thank you.
The Honorable Ryan D. Nelson serves as a judge on the U.S. Court of Appeals for the Ninth Circuit. Prior to his confirmation, Judge Nelson served for 9 years as general counsel of Idaho Falls-based Melaleuca Incorporated, a consumer goods company. He previously worked in Washington, D.C., working among other positions as special counsel for Supreme Court nominations to the ranking member, Senate Judiciary Committee, and deputy general counsel to the White House Office of Management and Budget. He was a law clerk for Judges Mosk and Brower of the Iran-U.S. Claims Tribunal at The Hague, and for now Judge Tom Griffith and Senate legal counsel during the impeachment trial of President Clinton. He also served as a law clerk to Judge Henderson of the United States Court of Appeals for the D.C. Circuit. Judge Nelson earned his BA from Brigham Young University and his JD with honors from BYU Law School. Mr. Michael Ferris is founding president of Homeschool Legal Defense Association and continues to serve as a board chairman. He is also founding president of Patrick Henry College, where he serves as Chancellor Emeritus, and he previously served as the president and CEO of Alliance Defending Freedom. Mr. Ferris is a constitutional appellate litigator who has served as lead counsel in the United States Supreme Court, 8 federal circuit courts, and the appellate courts of 13 states. Mr. Ferris has been recognized with a number of awards, including the Heritage Foundation Salvatore Prize for American Citizenship, and is one of the top 100 faces in education for the 20th century by Education Week magazine. Mr. Ferris graduated from Western Washington State College, magna cum laude, with a bachelor's degree in political science, followed by his Juris Doctor from Gonzaga University with honors. And he also earned an LLM in Public International Law with honors from the University of London. Last but not least, we have Professor Marcy Hamilton, who is a professor of practice in the Department of Political Science and Fox Family Pavilion non-resident senior fellow in the program for research on religion at the University of Pennsylvania. She is also the founder and CEO of Child USA, a nonprofit think tank that works to improve laws and policies related to child abuse and neglect. Professor Hamilton has been honored with a number of awards, among which are the 2019 Distinguished Daughters Award presented by Pennsylvania Governor Tom Wolf and the 2012 Pennsylvania Woman of the Year Award. Professor Hamilton clerked for Justice Sandra Day O'Connor of the United States Supreme Court and Judge Edward R. Becker of the United States Court of Appeals for the Third Circuit. Professor Hamilton received her BA from Vanderbilt University summa cum laude, her MA from Pennsylvania State University, and her JD from the University of Pennsylvania School of Law, magna cum laude. Without further ado, I welcome to the stage Judge Nelson. If we could all give another round of applause for our amazing panel.
Well, good evening, and thank you for coming tonight. As in the greatest of traditions, you come for the food and stay for the intellectual debate. And it's a pleasure to speak to such bright and inquisitive minds. And it's a particular pleasure to moderate this discussion between Michael Ferris and Marcy Hamilton, whose unique professional backgrounds make them extremely qualified to talk about whether the Constitution protects parental rights. As a Court of Appeals judge, I, as you know, am bound by Supreme Court precedent. And spoiler alert, the Supreme Court has, at least in part, addressed some of today's topic. But taking a step back, parental rights have been a solid basis in human history. God gave Moses as the fifth of the Ten Commandments, honor thy father and thy mother, that thy days may be long upon the land which thy Lord giveth thee. And table 4 of the 12 tables ratified in Rome in 451 BC states, quote, to a father shall be given over a son the power of life and death. So for thousands of years, parental rights have been recognized, ranging from Revelation to Roman common law. The concept of parental rights sure do seem implicit in the concept of ordered liberty. And there is evidence that these rights are deeply rooted in this nation's history. John Locke, profoundly impactful on the founding generation, wrote in his second treatise of civil government, from Adam, the world is peopled with his descendants who were all born infants, weak and helpless, without knowledge or understanding. But to supply the defects of this imperfect state till the improvement of growth and age hath removed them, Adam and Eve, and after them all parents were, by the law of nature, under an obligation to preserve, nourish, and educate the children they had begotten, not as their own workmanship, but the workmanship of their own Maker, the Almighty, to whom they were to be accountable for them. This is that which puts the authority into the parents' hands to govern the minority of their children. That certainly sounds like the beginnings of a natural law argument. And that brings me back to today's prompt. The Supreme Court actually locates the constitutional protection of parental rights in these following words contained in Section 1 of the 14th Amendment. Nor shall any state deprive any person of life, liberty, or property without due process of law. Significantly, as I expect may be discussed later, the court relied on the due process clause and not the privileges or immunities clause. And under this substantive due process framework in Meyer versus Nebraska, the Supreme Court a century ago invalidated a state forbidding the teaching of German to children because it encroached on parental rights. Piggybacking off Meyer in Pierce versus Society of Sisters, just 2 years later, the court struck down a statute requiring all children attend public schools because it infringed on a parent's right to send their child to a parochial or private school. The court has recognized a litany of parental rights under substantive due process, mostly in context of education and visitation rights. In Washington versus Glucksberg, a far more recent case, the Supreme Court set out our test for recognizing unenumerated rights protected by substantive due process. First, we must narrowly define the right asserted, and then we determine if that right is implicit in the concept of ordered liberty and deeply rooted in the nation's history. But the court has become increasingly skeptical of substantive due process. The court has described it as a treacherous field due to what it necessarily entails, recognizing often ambiguously stated or overbroadly phrased unenumerated rights and taking the regulation of activity protected under those rights away from the legislative ambit of the democratic process. With these concerns in mind, last year in LW by and through Williams versus Scrimetti, the Sixth Circuit upheld Ohio's restrictions on medical transitions for transgender minors, despite the parents of those minors claiming a parental right to make that medical decision. And contrary to every other circuit, in Sinclair versus City of Seattle, I concurred in that decision to note that the Ninth Circuit tacitly recognizes a parental right to recover for loss of companionship of an adult child without conducting the appropriate Glucksberg analysis. And finally, in Dobbs versus Jackson Women's Health Organization, Justice Thomas concurred, suggesting that the court should re-enter its due process clause recenter its due process clause jurisprudence on the original meaning of due process, which he argued focused less on the substance of what due process was meant to protect and instead focused on ensuring the process itself was procedurally sound before the deprivation of liberty. It's worth noting that none of the other justices joined Justice Thomas's concurring opinion in Dobbs. So the question still remains, does the Constitution protect parental rights at all? If so, what is the scope of those rights and how do we determine them? And should parental rights be protected under the Due Process Clause? If these rights are not protected by the Due Process Clause, are there other constitutional candidates for this unenumerated right? Your own law professor, Randy Barnett, has suggested one candidate for protection of unenumerated rights could be the Privileges or Immunities Clause, which obviously historically has been severely restricted after the slaughterhouse cases. And other academics posit that parental rights are rooted in natural law. Is that a candidate? Well, we'll get to all of these answers and more over the next 45 minutes to an hour. And with these questions in mind, I would like to invite our debaters to each give their opening statements. And we'll turn the time first to Mr. Harris, and then we'll turn to Professor.
Thank you. It's great to be here tonight. I appreciate the opportunity. Thank you for the kind introduction. I want to just briefly focus our attention on one other parental rights case. That's Troxell versus Granville from 2000, where the court split 6 different directions over the question of what constitutional protections are afforded to parental rights. In that case, Gary Troxell, who's an old rock and roll singer, he had a #1 hit in the 1950s with a song called I'm Mr. Blue, was at odds with the mother of his grandchildren. His son had a long-term relationship with her. They'd never been married. He died. The grandchildren had been visiting with Gary Troxell and his wife. He wanted to visit them more than Jennifer Troxell was willing. And so anyhow, or Jennifer Granville, I should say, were willing, and they had a dispute that went to the Supreme Court of the United States. The plurality said that parental rights have historically been treated as a fundamental right, but then they proceeded to not use the normal fundamental rights test in making their decision, and basically announced, we're going to decide this on a case-by-case basis. That was 24 years ago, and they've never taken another case on parental rights. So it's really hard to develop a case-by-case theory of the constitutional parental rights when you don't take a case more often than none every 24 years. The more notable decision was Justice Scalia's conclusion that parental rights are not protected whatsoever in the Constitution, at least in the substantive due process theory. Justice Thomas was the only justice to apply the traditional fundamental rights test, and he said it's only because the contrary positions were not argued. The Justice Scalia position was not briefed or argued in the case, and he didn't think it was the time and place to launch off into this territory. But he said, in the right case in the future, he'd be tempted to look closely at Justice Scalia's viewpoint. Other justices went varied ways, and the lower courts have been basically in disarray on parental rights ever since. So tonight I'm going to offer a new theory to rescue parental rights from this morass. And my theory is that parental rights properly understood are a species of procedural due process, and that there's no need for even entering into the substantive due process field, and I'll develop that in due course. I have 3 basic points. First, as I've just said, parental rights are best understood as a procedural due process rather than substantive due process. These rights arise from and are limited to the duties that parents owe to meet the needs of their children. Third, a breach of the duty of a parent to meet the needs of his child must be proven, that's the process, in order to override parental decision. I've published these thoughts and this theory in a law review article that was published this summer by Liberty University's Law Review, and I have a few copies here tonight. But you can all read it. You all have access to Westlaw and can get it online. Now, I turn to Justice Thomas because, frankly, my theory was born out of the necessity of recognizing if a parents' rights case gets to the Supreme Court of the United States, I need Justice Thomas's vote. And so I've been a litigator for a long time. I've taught constitutional law at the undergraduate level. I've written scholarly articles at times, but I'm more of a litigator than I am a scholar. And I would not make this argument, at least not by itself, in a courtroom. But tonight, I am freed from the necessity to actually win a case. And I'm going to tell you what I really think. And so this is what I really think. Now, the Supreme Court has decided 13 cases where parental rights were a central issue. And they were all resolved using some form of due process analysis. The 13 cases can be divided into three categories. First, cases involving termination of parental rights. Second, the second one is a close cousin of the first, cases involving parental rights of unwed or inactive fathers where their child was being adopted, thus a form of termination of that father's rights. And then third, cases involving governmental interference with a particular area of parental decision-making. It's this third category that has been decided using substantive due process. The first two cases have 100% been decided under procedural due process. And I contend that parental rights can be properly defined as the right to make decisions about and for one's child. It's decision-making. That's what really parents' rights amounts to. Now, the first two categories of cases involve removing all decision-making authority over a child. That's what's happened when you're deprived of permanent custody. You no longer can make decisions for your children, including where do they live? Do they live with you or not? And I will demonstrate, I had demonstrated in the article, that 100% of the justices of the Supreme Court who have decided these procedural due process cases agree that the right of parents to the custody of their children are protected by procedural due process. This includes Justice Scalia and Justice Thomas. The right of the parent to make decisions for their child is an undebatable, I can recognized liberty interest protected by procedural due process. Now, to be sure, in these cases, in these categories, there's been a debate about what process is due. They don't always agree on the outcome, but all of the justices agree that whatever procedures the state uses must comply with the components and the requirements of procedural due process. Now, parental rights have also been described by the Supreme Court using the cluster of rights analogy. It's one stick in the bundle of rights. And that's been applied not just in property rights, which we're most familiar with, but in a number of areas, 5 or 6 different areas. And parental rights is one of those 5 or 6 areas where they've been described as a bundle of sticks of rights, the ability to make decisions in a variety of areas: education, healthcare, discipline, religion, and so on. So my contention is basically this: if the government seeks to remove one stick in the bundle of rights, overriding parental decision-making on a particular topic, we should use the same constitutional standard that we use when they're taking away all of the parental decision-making. It makes no sense to have 2 different tests, a harder test when you're taking away one right than when you're taking away all of the rights. It simply doesn't make any sense. And I believe that procedural due process is the correct way of doing this. Now, the procedure should require that before the government can take away the right of the parents to make decisions for their children, they have to prove that parents have breached their duty toward their child in order to override their ability to make one decision or all of the decisions. It shouldn't matter. Now, I demonstrated in the law review article that I've written that even when the court has purported to employ substantive due process, the question of whether the parent's decision at issue is harmful to the child has always been considered. 100% of the cases, they're actually looking at whether the parent breached the duty to their child. I contend this is the real rule that's been in place, whether they recognize it or not. And the court has never even discussed, much less explained, why they use procedural due process in some cases and substantive due processes in others. It's an absolute mystery. So, turning to my second point, and I'll be brief, Justice Stevens, writing the majority in Lair versus Robertson, discussed at length the idea that parental rights flow from the duties owed to their children. That's my second. Parental rights flow from the duties owed to their children. And in the phrase, the right coupled with a high duty to prepare one's child for additional obligations taken from Pierce versus Society of Sisters, was central to Justice Stevens' analysis and is the best simple explanation of this duty principle in the time that we have. Now, my third point has already been covered, although very briefly. Proof of the breach of the duty is what's required to override parental rights. Like all of our rights, parental rights have never been thought of as absolute. For hundreds of years, Anglo-American jurisprudence has recognized the limiting principle that we can now describe as a parent's breach of the duty he or she owes to their child to care for them and their needs. Parents have rights, children have needs. These two principles are central to our society, and both should continue to be protected by procedural due process. Thank you very much.
First of all, let me thank the Federalist Society and Georgetown Law Center for the honor of being invited for this debate. I have done many Federalist Society debates, often carrying the opposing view. And I don't think there's going to be as much opposition tonight as you might think, but we'll see. So let me just start by saying that my answer to the proposition tonight is that parents have rights, but they are limited by children's rights. We disagree on the use of the term needs as what is driving children. In fact, the United States Supreme Court and the vast majority of our laws have recognized children's rights, and children's rights amount to, when taken together, the right of a child to an open future. In history, the vast majority of centuries, children have been property. They were the property of their fathers, and they were property for labor purposes. They were not persons. They were not persons under the 14th Amendment at the time of framing. But over the course of the 19th and the 20th centuries, we saw three different arenas of rights open, which have now become commonplace rights for children. I'm going to talk about their rights against abuse, their right to education, which is the flip side of their right against labor, and their right to health. Let me reiterate, children are persons. And so much of the common discussion about parental rights in the press presumes that parental rights are actually freestanding without reference to children. And that is a false reading of the Constitution. Let me start with abuse. There were no laws in the United States against abuse of children for a very long time. In fact, the first organization that was started to deal with cruelty to children was started in 1875, not until then, which was the founding of the New York Society for the Prevention of Cruelty to Children. That organization was founded 9 years after the APSCA, the organization protecting cruelty to animals. So what that shows you is the true property level of children until relatively recently. We now have thousands of laws that criminalize abuse of children, from sexual abuse to physical abuse to emotional abuse. There is no question that children have a right against being abused, and that is reflected in the language in the children's cases, in which the courts repeatedly say that there is a compelling interest in the protection of a child from harm. So that even if a parent has an interest, has a decision, makes a choice that is going to harm the child, the parent can be pushed back because of the rights against abuse. And that's a good thing. The largest category of abuse among children is by family members. Secondly, we have this flip side of two rights. We have the rights to education and the right against being put to labor. This, of course, the right against labor grew out of the Industrial Revolution. When children were working long hours in factories, they were dying, they were not being educated, and they were not being protected. In 1918, Hammer v. Dagenhart was decided by the United States Supreme Court, in which they held that it was unconstitutional to have a law that said that the products of child labor could not be sold. That case lasted for 23 years. But eventually the Darby decision came down, which opened the door to regulation of the marketplace for children and for adults from being harmed in the workplace. Recently, Justice Thomas and Justice Gorsuch advocated for the reversal of Darby, which would be the end of protecting children in the labor market. Prince v. United States was a later case, 1944. Prince v. Massachusetts. This is a case that says that religious liberty is not a defense to harming children. In that case, a religious parent was having their child walk on corners handing out religious leaflets. That was a violation of the child labor laws. The United States Supreme Court explained the principle that was the holding of that case. Parents may be free to become martyrs themselves, but it does not follow that they are free in identical circumstances to make martyrs of their children before they have reached the age of full and legal discretion, when they can make that choice for themselves. This is, in a nutshell, the right of the child to an open future, the right of the child to arrive at age 18 having not been abused, having been educated, and having not died and not be seriously ill because of the parents. So the Supreme Court has actually itself explained to us what the right to an open future is. But let me look at the right to education. The right to education is something that the Supreme Court has not done as well with respect to children. And part of that is because it has not examined what the harm is to the children in these scenarios. So in Pierce v. Society of Sisters in 1925, we learned that a parent can choose a private school for a child. And we can debate on whether or not that is a right for the child as well. But there's no question that that is the right of the parent to choose, where to educate the child. In 1972, though, the Supreme Court decided Wisconsin v. Yoder. As I am on record repeatedly saying, this is the worst religious liberty decision that the United States Supreme Court has ever made. It's twofold. If you read it, it is a love letter to the Amish, in which the court actually says the Amish do not break the law. As someone who does not live far from Lancaster, I'm going to say that's factually false. As someone who knows someone who had a buggy back into their car and caused thousands of dollars of damage, I'm going to tell you that is not true. But regardless, Chief Justice Berger, in his inimitable way, wrote an opinion in which the Amish are perfect, and then it's okay to take your children out of school early. The Supreme Court let our society down in that decision by not using the argument, which is the argument for compulsory education. It's the argument for education. We need educated citizens to be good members of a democracy. We need them to be able to listen at this point to social media and to question whether it's true or not. We need them to be able to choose the best rulers. So Wisconsin v. Yoder opened the door to a too large number of religious youth who have not been fully educated, whether you're talking about the fundamentalist Mormons, the ultra-Orthodox Jews, or the Amish. In 2022, the United States Supreme Court decided Carson v. Macon. What that case essentially did was it opened the door for religious charter schools to become a thing. We now have one in Iowa in which you have a Christian nationalist organization that is getting approval. We had one in Oklahoma where the Catholic school is not getting approved. But my point is that Wisconsin v. Yoder opened the door to failing to educate children. So if we're looking at this from children's rights, this is in fact a weak point. Let me just close by saying that the last right that the 19th and 20th century have brought to us is the right against death and serious illness brought to you by your parents or anybody else. Only 6 states permit parents to let their children die for religious reasons. 44 do not. What happens if you have the right to let your child die for religious reasons? You live in South Dakota, where a number of the sects have very large cemeteries. In those cemeteries, there are more children's and baby headstones than there are adult headstones. They don't believe in medical care for religious purposes, so their children die. 44 states, it is just commonplace for the United States Supreme Court to recognize that if the vast majority of the states have recognized a right, it exists. There is a right against being killed by your parents for any reason. Let me just close by saying this. As someone who started a nonprofit for children, Child USA, 8 years ago, and have been working on these issues for years, I never intended to do that. That was not intentional. I'm a law and religion scholar. I was going to do fancy First Amendment law for the rest of my life, especially after I won Bernie. But the harm to children in our society is so extreme that I could not do it. And so what Child USA stands for is children's rights not to be harmed. I think we might agree with that, but we're not going to agree on the same path to get there. Thank you.
Remind me how much time we have for this segment?
5.
5 minutes, okay, thank you. Well, thank you so much, Marcy. It's good to hear from you. We agree a little bit more than I was expecting.
Yeah.
But I'm not totally surprised. 3 quick points. Actually, 2 quick points and 1 more longer. Professor Hamilton and I read history differently. I don't believe that the record of history suggests, and I cite a fair amount of it in my law review article, suggests that children have ever been treated as property within the relevant timeframes that are relative to this country. It's just not correct. But that's a matter of getting our proofs out and putting them side by side. I think we all agree children are not property. Children are persons. I believe that they are persons from the moment of conception. And so I think that they should be treated as persons at all stages. So whatever the history suggests is what the history suggests. It should not be lawful, I'll agree with you right up front, to kill your children for religious reasons or any other reason in any state. And if 6 states allow that, then if that's accurate statement of the law in those states, I disagree with the law in the states. The rights versus needs paradigm. It is true that the Supreme Court has said that children have rights vis-a-vis the government. It is not said that children have rights vis-a-vis their parents. And the rights paradigm, I would suggest to you, only applies in the government context. Parents have duties, children have needs. A breach of the duties vis-a-vis those needs gives rise to legal consequences, just like in tort law. If you have a duty to take due care, you breach that, you hurt your neighbor, there are consequences for that. Breaching your duty of your needs, your child's needs for education, for healthcare, for food, for anything else. The child doesn't have a right to those things, because if it's a right, the government has the duty to furnish those needs. And the whole framework of the UN Convention on the Rights of the Child, which I have basically led the charge to make sure that it never gets adopted by the United States and successfully done so for a long time, is because it breaches that paradigm. It takes children's rights and places them in the needs category. And we've successfully made sure that that doesn't happen in our country, at least heretofore. So yes, children have rights vis-a-vis the government. you take away a child's liberty in a juvenile justice context, they have rights. And in another context as well. Kick them out of school, public school, they have rights, but not vis-a-vis their parents. They have new needs and duties. Now, the open future, of course, the examples used are the most egregious that are difficult for everyone to look at, as a desirable outcome. But I have in mind that open future means something quite different. I don't think, first of all, the Supreme Court's ever said that that's right. I think that's a made-up theory. And I don't think it's found in history or found anyplace else. It's found in scholarly writings of people who share the viewpoint of Professor Hamilton. It's an interesting construct, but it's made up, a recent vintage. But there are enough law review articles written about homeschooling that I've looked at closely over the time that tells you what it's really meant by this. Professor Martha Albert Finneman at Emory contends that all private schools in America should be not allowed to proceed. And everyone should have to go to the public schools because otherwise we're not going to give children the right educational philosophy that the current elite wants to make sure that all children have. Catherine Ross at George Washington Law School says much the same thing. She has a complicated last name. It's like Katzenbeck, but I'm blanking at it at the moment. The former dean of Northwestern Law School, Kimberly Urraco, has also written that parents should not have the right to give their children a homeschooling education. Why? Because they're teaching against the Enlightenment. The desire to make sure that other people's children are raised in your worldview is the essence of what the open future theory gets down to at the end of the day. In the UN Convention, in the Universal Declaration of Human Rights and the International Covenant on Civil Rights, Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, all three recognize the rights of parents to direct the education of their children so that the children will have the moral philosophy of the parents. Why do we have those things in the law? It's because all of those documents were written as a response primarily to the atrocities of Hitler. Hitler wanted the children to believe what the state wanted them to believe. And when the people like Kimberly Urraco and Martha Albertson Finneman and others want all children in this country to believe what they believe and want to use the government to brainwash children according to their value system, the answer is found in the Universal Declaration of Human Rights. The answer is found in the economic, cultural, and social rights. Parents have the primary right to direct the education of their children. The open future, the future is parents have the right to ground the moral education of their children.
So we can just both say each other's making it up. I mean, that's fine. But I'm going to dig in on the Supreme Court actually talking about the right to an open future. You know, these are not magic words. The collection of laws that have appeared since the 19th century for the protection of children, which did not appear before, have created a universe where children are actually protected until age 18 from serious harm. But they're also protected so that they are productive members of society. There is a right to an open future if you read the cases and you're not just looking for the adults. As I say all the time, adults prefer and protect adults. If you start a conversation about the protection of children, it will fizzle off into what are we going to do about the adults? If you stay focused on the children and you look for the children in the cases, you get a different reading. Wisconsin v. Yoder is featured here because Justice Douglas actually pointed out what was wrong with this decision. Nobody asked a single child that was involved in the case. Now, they assumed these children wanted to do what their parents were doing, which was taking them out of school early, but no one asked. And what Douglas said quite correctly is that in the next case, that's what should be asked, not just what it is that the parents want to do. So let me just very quickly close then. Right now, there is a big push in the United States for laws that roll back all of the rights I've mentioned, quite shockingly. But one of them is a push to create fundamental rights for parental rights. The arguments in favor are legion to give parents unfettered decision-making regardless of harm to the child. That's what fundamental rights now believes. I don't think that's what Mike Ferris believes, but that's what's going on around the United States. And let me close with RFRA, the Religious Freedom Restoration Act. It puts parental rights arguments on steroids. Because remember what RFRA says. It says neutral and generally applicable laws don't have to apply to religious believers if they can show a substantial burden, which the Supreme Court has turned into any burden imaginable. What do we have with respect to children's laws that RFRA could overcome? Laws for labor, education, abuse, medical treatment, vaccines, child protective services, gun access, custody, adoption, emancipation, AI-driven images on the web, which are, by the way, primarily created by parents. Safe environment requirements, food neglect. RFRA undermines neutral and generally applicable laws that are right now protecting children. And so when you add the fundamental right to a RFRA in a state, what you end up is an unprotected child. And that takes us right back to, and we're going to have to disagree with this, to when children were property, when they didn't have rights, when they were unprotected by law, and their fathers owned all abilities to decide where they go and what they do. Thank you.
Well, I'd like to thank both of you for sharing your views on this, and we'll open it up for questions. So be thinking about questions, but I wanted to start off with one that I think kind of came out of this. It seems like there's a disagreement. Professor Hamilton, you are saying that that this is the difference between children having rights versus needs. Could you explain a little bit more about how that difference would play into like a real life situation such as homeschooling? Do you think therefore that because children have rights, that changes the homeschooling analysis that the Supreme Court has given?
I do. I do. So there's been a very strong push to make homeschooling unaccountable and unregulable, and that is a very strong movement right now. If there are no enforceable regulations that require a certain level of quality education for the child, and the parent is not providing that level, so they're not learning to read, they're not reaching their benchmarks, then you have a situation where this would be the right of the child to be educated regardless of the fact the parent has decided not to educate them. So yes, so in terms of education, absolutely.
And so what would you propose to do as you think as long as there's some regulation of the homeschooling curriculum, that would solve? You're not opposed to homeschooling, but just that they have some guidelines.
Right, no, I'm not, no, Child USA, I am not opposed to homeschooling per se. I'm opposed to not educating children. And so the answer, so we're going to be publishing a very significant study later this month in which we're going to lay out every law in the United States with respect to education. And what we found is that the lack of regulation of education beyond public school, there's lots of regulation, is extraordinary. And what that's doing is it's leaving children in the lurch and not being protected. So, so we are in the process of working on trying to figure out, well, what would be, what would count for quality education for the child coming out of homeschooling?
And then let me get a response on that. I mean, do you agree that some regulation is necessary, or should it should just be set by the sideline because it's going to be too onerous by the government?
There's a form of regulation of homeschooling and private schooling and public schooling for that matter in all 50 states. It's called educational neglect. That is a concept, and unless it's changed in the last couple, 3 years, it is the law in all 50 states. Now, do you need to have a law that says you have this many hours of instruction? The instructor has this level of credential. You do these exact things. When you start regulating the details, I don't think that that's necessary. There's no evidence that that produces a better quality. But to say that a child should not be able to learn to read, you'll never win that. I've litigated more homeschool cases. In fact, I may have litigated more parental rights cases, especially at the appellate level, than anybody else in the country. And I can tell you, you can't win a case if you don't teach your child to read. You don't teach your child to read, you're going to lose. Every homeschool case I ever tried, I walked in with the belief the first duty I had was to convince the judge these kids are okay. If I didn't convince the judge that these kids are okay, I didn't care what my legal theory is. He's going to find a way to rule against me. If I prove the kids are okay, he'll listen to my legal theory. I may or may not win, but I will lose for absolutely certain if I don't prove that the kids are okay. And so I think that's, it's not the way it works in real life. I think that part of the, there's no laws against child abuse and all that. That's the difference between common law and statutory law. It may be true that there were not a bunch of statutory law in the question, but it's been a common law problem for time out of mind to abuse your children. And so just because there isn't a statute on it, and we looked at the dates of statutes as finally giving children protection, I can cite Blackstone, John Locke, and so on to show you to the contrary, that back when we were dealing just common law, there were protections, there were limitations. And so the idea of a regulatory state, I would just, someday I probably will have to get into this and do it. And that is, give me the highly regulated school. Let me put the public school on trial, and let me put my homeschool family on trial, and let me do the same kind of analysis. The public schools will never pass that analysis. I was a witness 30 years ago or so when Albert Shanker, the president of the American Federation of Teachers, the second largest teachers union in the country, testified before a hearing in I think it was the Russell Senate office building, that 2/3 of the graduates of public schools were functionally illiterate, meaning they couldn't rank order 7 fractions, and they couldn't write a simple coherent paragraph in a business letter. Graduates. Now, if that's the standard, if regulation produces excellence, I give you the public schools as the example of utter failure. Regulation, that kind of regulation, but to hold them to the standard, if you don't actually teach them to read, if you don't actually teach them to be literate, you're going to suffer consequences. I'm all for it. Apply it to the public schools.
Okay, so let me just say 2 things in response to that. In fact, all of the states do not have educational neglect laws. That's a fact. And many of the states do not have enforceable educational neglect laws. And this whole notion of abuse being in the common law, I'm sorry. There are still states in the United States where there is an exception to child sex abuse for incest. That's right. Family-based sex assault is okay.
Well, it shouldn't be, and I'll work with you
well,
to stop.
Of course it shouldn't be, but my point is the history, the accuracy of history. Children were wantonly and permissively abused until relatively recent. Now, with respect to the, speaking as a public school a product whose children went to, I don't know, we all went to okay schools. Penn, Columbia, Dartmouth, Middlebury. One's a doctor, one's a lawyer. So I'm not going to put up with the wholesale trashing of all the public schools. We know that's not correct. But Is it possible to be well educated in a homeschooling situation? Of course it is. Get Mike to be your teacher. It's possible. It's possible to have a wonderful education, but many do not. Many do not, because we know from a number of people who have come forward. So the question is how do you make it so you can have homeschooling without the harm to the child? And I think that's one of the big questions of the era right now.
So, Mike, you mentioned that the Supreme Court hasn't really taken one of these cases in 24 years. Obviously, Scrimeti is the case that has now just been taken. Are you willing to kind of give a prognosis of what you think is going to happen in that, and to what degree of parental rights going to come up in that case, or other issues going to override that?
That's a
loaded question.
It's really loaded. It's really hard.
Yeah.
It's hard to predict.
Yeah.
Obviously, parental rights have been argued and will be argued in the case. I hope and believe that that's not going to be the basis of the decision, because I don't want to see broad pronouncements limiting parental rights in a case where I agree that the state has the ability to do what the state wants to do in this particular case. Just to say, I think that sexual transitioning of the medical sort of, that's being banned by this is harming a child. It is a breach of the duty, and I think the state has a right to define what harm is, and Tennessee has decided that, and they've passed a law appropriately. But if there are broad pronouncements about parental rights in that context, I don't know that I would like the outcome. I'd like to rather have it more carefully drawn. And it's a little odd that the United States government is the one that's really raising those arguments, because but in fairness, First versus Society of Sisters, it was schools, not parents, raising the arguments, and so that derivative kind of argument of parental rights has happened. It's a tough case to predict, and who knows? We'll see.
Do you want to weigh in on the case and what you think or want to have happen, or?
Well, look, I'm not predicting the current Supreme Court. I predicted the Supreme Court until about 5 years ago. I give up. It's not the same Constitution we had. So I don't know what they'll do. What I do hope happens is acknowledgement of the child's rights, and of the child's perspective of the consideration of the harm to a child who has been born in a way that they are not comfortable in their body. So we couldn't disagree more, but it's largely religious on whether or not sex changing for a child is inappropriate. But I think it's very unfortunate. Oh, well, my faith is not his faith.
Because science is.
Sorry, I disagree, Jordan. So here's the issue, is whether or not they will take into context the needs and the perspective of the child, regardless of what the parent says. And we'll see.
So are you viewing it less as a parental rights case and more as a children's rights case?
I view it as the way in which child abuse is defined, and whether it's going to be defined by primarily religious precepts or is going to be defined by harm to the child. And the religious precepts are out there. The science and the harm to the child is different.
It's just not correct.
Well,
I mean,
we completely disagree on this.
Go read the science. I'm happy to follow the science on that.
I'm happy to follow the science, but my science is not tempered by my faith, because I don't have a faith that's in opposition to transsexual children.
And the cast review wasn't religious. Sorry.
No, this is a good opportunity to put it out for questions. Go ahead.
Yeah, I worked on the Scrimeti case at the appellate level. I mean, every European country is backing down off these laws. What would you say to that? Just out of curiosity. I know it's not.
Are you
exactly
speaking
what
to
we're
me?
talking about. Yes, yeah. Almost every European country now is reversing these laws.
Is backing off on which laws?
Laws saying you can provide a gender transition to a minor.
I am shocked to be at a Federalist Society event being told to follow Europe, but sure.
You're saying the opposition is religious. I mean, is your assertion that like the England's
If you
National
follow the
services.
public debate,
captured by ADF? Like,
no, if you follow the public debate on this issue, it is largely religious. Come on.
it's not what the court's interpreting.
It's not what?
It's not what the court's looking at here.
Well, of course not.
Whether the state can look at data and say, hey, we're banning a transition for a child.
Sorry. We live in a pre-Christian nationalist society and this is part of it.
Any other yeah, go ahead.
To Mr. Ferris, if your argument is that parental rights are procedural in nature rather than substantive, what is then the substantive scope of a parent's duty to his or her child in society? I mean, why not then ground parental rights in something like the Ninth Amendment or just wholesale in substantive due process? Why limit it purely to procedural due process?
Well, the question is, what's the scope of the liberty interest that's protected? And the Supreme Court, and that's the first question. The second question is, in what ways can you breach that and what are the duties? And those are kind of three but related questions. And the Supreme Court itself has listed a number of areas of decision-making that falls within the scope. Education, moral decisions, healthcare, discipline, religious decisions, and so on. There's a pretty comprehensive set of components of the sticks of the bundle of rights that the Supreme Court has recognized. But the ultimate test is, what are the sticks that are historically recognized that would be within that liberty interest? I believe in the originalist philosophy, and so you go look for history to see what the scope is. What were the duties owed? And you can see in Locke and Blackstone, early laws and so on, the duty to educate your child was there. And so a breach of that duty was actionable, and it should be actionable. So the scope of the decision-making authority, the duties that flow with that decision-making authority, and the breach of that, there's all historical components that need to be built up and get a robust body of knowledge around it. But that the framework is, what does history tell us about all those things?
Thanks for coming, Professor. This is so great. I understand you sort of at the end to say that you think the Religious Freedom Restoration Act is sort of harming children's rights, ostensibly from moving us out of Smithland or states get rational basis review to strict scrutiny. And I'm wondering if you can elaborate a little more on why you think that's a bad thing. It seems like it just may make the government show its work some more and may not be able to sweep so broadly. I'm thinking about child labor law. So maybe the government has a very compelling interest in not having 10-year-olds in mines for 12 hours. It might not have as compelling of an interest to have a 14-year-old, touching a touchscreen at Chick-fil-A, taking an order. And so maybe it'll just have the government sort of, have the courts sort of do better means in balancing here rather than allowing the government to sweep quite so broadly. So maybe just elaborate on why you think that.
Yeah, I highly recommend reading Bernie and the United States Supreme Court assessment of its own doctrine. The RFRA is not strict scrutiny. The least restrictive means test has never been part of strict scrutiny. It is a step beyond. And if you look at the doctrine as it's applied, the RFRA cases, they don't even bother at this point to get compelling interest because they're so busy jumping to what the least restrictive means is. So if you're looking at the least restrictive means, there was a woman in Indiana who beat her child with a hanger. The child was 5 years old and horribly disfigured. The woman was arrested. Her defense was that if you spare the rod, you spoil the child. She invoked Indiana's RFRA. What is the least restrictive means between putting her in jail and giving her probation? It's probation. So what is usually, so what we deal with in society right now with RFRA is a mass lie, which is that somehow RFRA is the Constitution and that somehow that standard is constitutionally based. As the United States Supreme Court has made clear, it's not. It's a much higher standard, and it's a higher standard Because no law stands unless it's the least restrictive means for one believer. So the short answer is children are at much more risk under RFRA.
I was the co-chair with the drafting committee of RFRA, as Professor well knows. The other members of the drafting committee, American Jewish Congress, Mark Stern, American Jewish Congress, he was my co-chairman, the ACLU, People for the American Way, all the major Jewish organizations, all the mainstream Protestant organizations, religious groups of all kinds, and notably the ACLU. We wrote the operational agreement when we wrote RFRA was we were going to follow the pre-Smith law exactly, and we were going to do our very best to put it into statutory framework. And that was the agreement, and I believe and can defend that's exactly what we did.
You cannot defend it because the United States Supreme Court rejects your reading of their doctrine.
Well, no, they rejected it because they said that we granted more freedom than Smith.
No, they did not.
No,
They said that the least restrictive means test is much harsher.
that,
It
that's,
creates a new standard that is not proportional to the harm that was chosen. I should know. I wrote the brief they used to write the opinion.
I get it. You won, but you thought you won more than you actually won.
Oh,
You
no,
thought-
no, no, no,
Let me finish.
No,
Let me finish.
no,
You
no.
can come back.
No.
She thought she'd taken out RFRA entirely. She took RFRA out only vis-a-vis the states. She didn't take RFRA out vis-a-vis the federal government. It's still in place. It's still used. Why did Hobby Lobby win their case on birth control?
Because it was reenacted in 2000. It had to be reenacted.
So the RFRA protects religious freedom, and I I'll stick by it, and we debate the history, but the reality is the parade of horribles that she offers, you can't win cases like that. Maybe people make arguments, but you don't win cases like that. I've litigated RFRA cases at the state level.
They won Hobby Lobby.
Well, yeah, and they should have won.
No, they shouldn't have.
Well, of course. Because abortion trumps everything. So,
Hobby Lobby trumps the woman's right not to be discriminated based on religion at her workplace? No. Neutral generally applicable law lost in Hobby Lobby. And so.
true, that's the point. Neutral general laws should lose to religious freedom.
No, they should
because-
not.
Well, that is basically it.
That's Christian nationalism.
No, it's not.
Yes, it is.
Okay.
Yes, it is.
Well, this is getting just what it's. I'm like, can we extend this for another hour? Let's take one more. She has a hot question, so we'll take one more and then we'll close it out.
I wanted to go back to like the religious point of that you mentioned earlier about like 6 states allowing like the death of a child because of religious like freedoms getting in the way. What would be the solution in that case? Would it be that you force them to go against their religion and then maybe like suffer the consequences of the child now being like banned or scarred or looked down upon because of like breaking the religion? Or is it like, is there another solution that maybe is that I'm not seeing?
I'm sorry, what's the factual scenario?
Like a child wants to go get aid and their religion doesn't allow them to. Obviously, you're advocating that that shouldn't be the reason that they don't get like a blood transfusion that like they can't get because of their religion, but then they end up dying because of it. And so if your goal is to save the child, would that then force them to go against their religion and then cause them to be at odds with the family that's supposed to be protecting them? So
The
like
44 states currently that don't let parents let their child die for their faith would save that child. What happens is that the child is temporarily under custody of the hospital. The child receives the life-saving care, and the child is given back to the parents. That is commonplace. 44 states. It's highly unusual for a parent to be able to make the decision to let their child die, and the society stands by and lets it happen.
If I could just tell you the story of a case that I litigated that's in this area. And it also tells you about the fundamental rights test. I helped write the Michigan law that says that parental rights are a fundamental right. And the reason we did that is because I argued 2 cases in the Supreme Court of Michigan on the same day. One for Christian parents, one for secular parents on the right to homeschool. I won the Christian parents case 4-3 from the Supreme Court of Michigan, arguing religious freedom using hybrid rights analysis from Smith. I lost the secular parents' constitutional claim, one on a procedural ground, but so they walked away, but we lost the big issue of the case, 4-3, because they decided parental rights were not a fundamental. So the net effect of those 2 court decisions is that religious parents in Michigan can homeschool their kids and secular parents could not. Religious homeschoolers went to the legislature of Michigan and said, this is not right. We need to fix this. And a number of Christian legislators, including a current member of Congress who was in the state legislature at the time, pushed this bill forward that said parental rights are a fundamental right. Fast forward, call it 20 years later. I'm in a courtroom in Upper Peninsula, Michigan, defending a family whose son, 8-year-old boy, had Ewing sarcoma, which is a form of cancer that grows alongside in his case, alongside the spine. The family doctor discovered the sarcoma. They went to Children's Hospital in Grand Rapids, had surgery, removed the tumor as best they could, and they did a round of chemotherapy. When they were done with that round of chemotherapy, everything that you could tell objectively, all the tests, everything you could detect is the boy was cancer-free at that point in time. The boy said, he was told that the doctors wanted to continue another round of chemotherapy. He said, I'd rather go be with Jesus than do that. And his parents and family doctor became alarmed that he was losing the will to live. And so the family doctor said, we can just watch and see if this recurs. We can stay on top of it, and if he has a problem, we can go back. The family was criminally prosecuted, parents were criminally prosecuted for refusing to follow the doctor's suggestions. Now, I was able to prove through depositions that the doctors were actually performing an experimental treatment. The drug that they were using had not been proven to be safe and effective for treatment of juvenile Ewing sarcoma. And so we were in a gray zone. Was the child really sick? Well, the tests say no. The doctors say, well, we think he might be. Was the treatment safe and effective? And that was clear that we didn't know. I mean, it was not proven. They thought it would be, but it was not proven. And so the question of the parents' rights, make the decision when we're in the gray zone. And these parents, like all the parents I've ever defended, love their children deeply. And one thing that I actually take offense of is when the comment that when you get adults around, they're making decisions that benefit the adults. That's not been my experience in dealing with thousands and thousands and thousands and thousands and thousands of families. And as a father of 10, I deeply resent that remark. But I argue to the court in this case is if it was clear that this boy was sick, and it's clear that this treatment was safe and effective, and the parents refused to do it, you should take the boy away from his parents and give him the treatment that's safe and effective that's needed to save his life. But that's not the case here. And the decision is, who has the power to make the decision when we're in the gray zone? And in the gray zone, I contended that the parents had the right, and I won that in the trial court. We went up on the appellate court. The family doctor discovered the chemotherapy, or the cancer was coming back. They immediately come to a different hospital. They didn't do experimental treatment. He was treated, and he lived for another 5 or 6 years, and he eventually did die. But the parents were willing to give him treatment at every point in time. At the point, no parent should be able to deny life-saving treatment to their child when the treatment is known to be safe and effective. That's just not right. And I will, you ever want me to say that in court, I'll do it anytime you want.
Well, listen, this has been a great debate. Why don't we give 1 minute to each? I know that's going to be hard to limit to 1 minute to kind of sum up what all we've discussed, but Professor, if you want to go first and then.
Sure. We agree on that last case, by the way.
Yeah.
for obvious reasons. So let me just say that we have a situation here where we have competing constitutional rights, competing rights of a child and a parent. And in most scenarios, they need to be taken into account. The parent is going to have wide latitude in many, many circumstances, but not in circumstances that are going to mean that when the child arrives at 18, that they have either been abused or they have not been educated or they have not been given the kind of treatment, life-saving or otherwise important treatment that they needed. Let me just close by saying this. These are issues that we should all care about. They should be bipartisan and they should not be political. Children need protection, but children need to be protected as well. Mike and I will never agree on his adamant refusal to let the Convention for the Rights of the Child be ratified. It is a humongous error in the United States for the protection of children. But on that, we have a lot of other agreements. Thank you.
Well, that's a short way out, perhaps. The Convention on the Rights of the Child not only has some bad substance, there's some good things in it, but I believe one basic principle: Americans should make the law for America. That if we're going to live in a self-governing republic, we don't need the UN or their committees ever making decisions and telling us in any fashion what our law should be. If they want, if it was a yada statement, that's a fancy term. I want to explain to you, you ought to do this, you ought to do that, you ought to do the other thing. It was nothing more than a yada statement. Fine, you know, make yada statements. But when you want to make international law binding on the United States in any kind of fashion, I will oppose that to my dying day. So. But this has been fun, and it's great to see you again.
Yes.
All right. Thank you.
That's what
It's basically.
That's not what you're not gonna